Well, good afternoon to you all. Thank you for joining us at our 2TG webinar today. Our subject this afternoon is the recent Court of Appeal decision in Calma and African Minerals Limited, a case where I acted for the defendant together with Robert Cumming and Andrew Bershadski, who will also both be speaking on this webinar. I expect that some of you may have attended a seminar we gave last year after the first instance decision of Mr. Justice Turner. The Court of Appeal upheld his decision and dismissed the appeal. The claimants are now seeking permission to appeal to the Supreme Court, and the Supreme Court's decision on permission is awaited. There are a number of points of interest arising from the case, and it's relevant not only to those who practice in the field of human rights law, but also to those of you whose practices cover tort law more generally. In particular, the Court of Appeal judgment contains a very wide-ranging analysis of the law of accessory liability for common design, and in respect of duties of care, in respect of the acts of third parties. Our webinar today should last for about 30 minutes or so. If you have any questions, do please email us after the webinar, and we'll be very happy to respond to you. I'm first going to introduce the facts and outline the issues, and Robert Cumming is then going to speak on the Court of Appeal decision on accessory liability for common design. And Andrew Bershadski is then going to address the Court of Appeal's approach to liability for the acts of third parties. Turning then to the facts, this was an action brought by 142 claimants who were local people who lived near an iron ore mine in Sierra Leone in West Africa. The claim arose from human rights abuses committed by the Sierra Leonean police against a large number of local people during 2 incidents of public disorder. The defendants were companies connected with the operation of the mine. One of those companies, African Minerals Limited, or AML, was registered in England. That enabled the claim to be brought here. And whilst the action was brought in England, I should say that technically the case was decided on the basis of the law of Sierra Leone. However, it was agreed that in all respects, Sierra Leonean law was the same as the law of England and Wales. So the analysis of the judge and the Court of Appeal are of general application in this jurisdiction. In 2000, the largest iron ore deposit in Africa was discovered in Tonkalili. This is a very remote and inaccessible district in the north of Sierra Leone. In the dry season, it's a 5-hour drive from Freetown along largely unmade roads, and in the wet season, it takes considerably longer. The open-cast mine was an enormous undertaking. To get an idea of the scale, the court was told that if superimposed on a map of London, it would stretch from Greenwich to Chelsea. Not only was there the mine infrastructure, but a railway 200 kilometres long was also constructed from the mine to a new port on the Atlantic coast. The mine was also the single biggest contributor to the Sierra Leonean treasury. Now, for local people, it was very much a mixed blessing. Before the coming of the mine, they lived and worked in very traditional communities. Most local people depended for their livelihoods upon small-scale trading or the subsistence farming of rice and other crops. For some, the mine brought employment and prosperity. For others, it brought only great dislocation and disruption to their way of life. Indeed, whole villages were relocated. And inevitably, this led to tension and conflict between local people and the mine. An important issue at the heart of the case was the defendant, AML's, relationship with the local police. As the judge found, the police force in Sierra Leone is relatively poorly financed. When AML arrived in Tonkalili, there was hardly a police presence in the area at all. In order to ensure that the mine and the railway were protected, local police support was required. The mine therefore assisted the local police with logistical support, and this included the provision of vehicles and accommodation, and also the payment of cash. It was inevitable, therefore, that there was quite a close relationship between the police and the mine. This is a state of affairs which, whilst it may be unfamiliar in the West, is not uncommon in the developing world. And moreover, it's well recognized that some police forces in the developing world have a poor human rights record, as indeed, I suppose, do some in the more developed world. As a result, Western companies operating in the developing world need to take care to ensure that they're not complicit in human rights abuses by local police or give unwitting support to such abuses. If they do, then they may expose themselves to the risk of litigation. The United Nations has issued a document, Guiding Principles on Human Rights Abuses, which emphasizes the corporate responsibility to respect human rights. And in the mining and energy sector, there's a specific agreement called the Voluntary Principles on Security and Human Rights, which sets out best practice where UK mining and energy companies have to interact with local law enforcement agencies. These voluntary principles require, by way of example, that the risk of human rights abuses by local police should be risk assessed. An important part of the factual background in this case is that the police had in the past been known to be violent and to have used disproportionate force. Hence, that was a risk to be borne in mind by AML when dealing with the police. Now, I mentioned the potential for tension between the mine and local communities. Things came to a head in two incidents, one in 2010 and one in 2012. These were both incidents of public disorder, which were met with a violent response by the police. The 2010 incident was at a place called Utinella. Here, local people protested against the fact that land was being used for the construction of a dam and the mine. They put up a roadblock and then detained some of the defendant's personnel for some hours. The police were called. They responded by using tear gas and firing live rounds into the air. Thereafter, things deteriorated. The defendant's property was attacked, 2 vehicles were hijacked, a drilling rig was set alight. That night, the police arrested many people in the surrounding villages. Some people were assaulted, some were held by the police at the mine for a time. Many were taken to local police stations and prisons where they were held in harsh and degrading conditions for many months. They were all prosecuted in the magistrate's court, but the case was ultimately dropped by the government. And the police were able to use the defendant's vehicles in the course of these operations. The claimants also alleged that the defendant's own employees, especially a man named Leone, was implicated in all of this. Matters flared up again in 2012, this time in Bambuna, the largest town near the mine. The problem started with a strike by mine workers seeking better conditions. This led to them putting a roadblock across the road to the mine. In due course, armed police arrived. They cracked down in a very heavy-handed way. There was then a serious outbreak of public disorder and a riot ensued. The police responded with live rounds. Tragically, one young woman was killed. Others suffered gunshot wounds. Still more were assaulted and detained. Again, on this occasion, the police were using the defendant's vehicles. And it was particularly alleged that one of the defendant's police liaison officers was driving the police around and directing the police. So that was the background. The claims, as I say, were brought by 142 claimants who said that they'd all suffered at the hands of the Sierra Leonean police and all the defendant's employees. 6 lead claimants were identified. Now, the focus of our webinar today is on the substantive legal issues, but it is, I think, worth noting that the case also addresses 2 particularly interesting practice points. First, certain witnesses were permitted to give evidence anonymously because they said they feared for their personal safety, and that's the subject of a separate judgment. Secondly, in a very rare move, the court was transferred to Sierra Leone for 2 weeks, where the judge sat as a special examiner in Freetown, so that the evidence of many local witnesses could be taken. Turning then to the more substantive legal issues, the claimants argued that some of the defendant's own employees were directly responsible for the violence, but that was rejected on the facts. The focus of the case, therefore, was on the violence of the police. Whilst it was clear that the police had behaved with wholly disproportionate force in both incidents and were clearly culpable, the police were not sued directly. The central issue, therefore, was whether AML, the defendant, could be held liable in respect of the acts of the Sierra Leonean police force. And the claimants sought to make the defendant liable for the acts of the police in 3 main ways. First, they said that the defendant was vicariously liable for the actions of the police. Secondly, they said that the defendant was jointly liable with the police because the defendant was an accessory and acted together with the police pursuant to a common design. And thirdly, they said that the defendant owed the claimants a duty at common law to prevent the police from acting as they did. Now, the High Court trial lasted 24 days and a total of 67 witnesses gave evidence, but Mr. Justice Turner dismissed all the claims. He held first that there could be no vicarious liability for the police because the police were not in a relationship with the defendant which was akin to employment. He held secondly that there was no accessory liability for common design because whilst AML had rendered assistance to the police, AML had no intention that the police should act tortiously or with unlawful violence. That was notwithstanding the fact that violence by the police was foreseeable. And he held thirdly that AML did not owe the claimants a duty of care to prevent the abuses committed by the police, essentially because, generally speaking, there is no duty to prevent harm being caused by a third party. This is because it's a type of omission rather than a positive act. And again, generally speaking, and subject to exceptions, which we'll discuss, no duty is owed in respect of an omission to act. So the case was lost. The claimants appealed to the Court of Appeal on two main points. First, accessory liability for common design, and secondly, the imposition of a duty of care on AML in relation to its failure to prevent the police from behaving as they did. Lord Justice Coulson gave the lead judgment in the Court of Appeal. The judgment is of wide-ranging application and has provided helpful clarification in these two difficult areas. At this point, I'm going to thank you all for listening to me, and I'm going to hand over to Robert Cumming, who will explain the Court of Appeal's approach to the common design issue. And after that, Andrew Bershadski is then going to go on to consider the Court of Appeal's approach to the duty of care issue.
As Neil set out, one of the key legal issues of interest at first instance and on appeal in this case, and perhaps the least well understood, was the question of common design, which is otherwise known as accessory liability. In seeking to make the defendant mine liable for the acts of the Sierra Leone police, the claimant's case was that the defendant was jointly liable for the police's torts because the defendant had joined in a common design with the police. Common design is another way of saying common intent. The concept is quite simple. It's that two parties combine together to commit a tort. One does the tortious act, in this instance, the police. The other provides the assistance, in this instance, said to be the mine. Common design was recently thoroughly considered by the Supreme Court in the case of Fish and Sea Shepherd. And it was defined by Lord Toulson as requiring proof of two elements. First, the defendant must have acted in a way which furthers the commission of the tort by the tortfeasor. That's the assistance aspect. And second, the defendant must have done so in pursuance of a common design to do or secure the doing of the acts which constituted the tort, the intention. Now, turning to the facts of this case, it was the claimant's case that the mine had assisted the police with the provision of accommodation, the provision of money, and the provision of vehicles. And it was alleged that the mine shared a common design with the police that there should be a crackdown on protests. Mr. Justice Turner, as the trial judge, found categorically that in relation to both the 2010 and the 2012 incidents, the claimants had failed to prove the necessary intention on the mine's part. He was not satisfied that it had been the mine's intention that unlawful means should, if occasion required, be deployed to resolve the recurrent disputes. In other words, there simply was no common design shared between the police and the mine. C sought on appeal to challenge the conclusion in relation to intent. They said two things. First, that Mr. Justice Turner had failed to take into account evidence relevant to the question of intent. And second, and in the alternative, that his conclusion was plainly wrong in light of all the evidence and his own primary findings of fact. As you heard from Neil, it was Lord Justice Coulson who wrote the leading judgment in the Court of Appeal. And he addressed the appeal in relation to intent at paragraphs 57 to 109 of that judgment, to point you in the right direction for some light bedtime reading. The claimant's first argument was that the judge had failed to take into account evidence said to be relevant to the question of intent. Now, that was said to be a short video clip taken on day 3 of the 2012 incident by the police. And this argument, no doubt, was run in an attempt to try and get around the inevitable difficulties for the claimants of the judge's findings of fact on the issue of intent. In any event, this argument was given pretty short shrift. Plainly, the trial judge had considered it. It was referred to in his judgment. And in any event, it did not show what the claimants wanted it to show. As such, the claimant's appeal stood or fell on whether Mr. Justice Turner's conclusion on intent was plainly wrong. The claimant said that intent ought to have been inferred on the basis that the mind could foresee that the police might use excessive force, and that by providing them with money, vehicles, accommodation, they clearly intended that the protest should be quashed, if needs be, by the use of unlawful force. The argument emphasised what actually was an uncontroversial point, that the required intent could be conditional, so that, to provide an example, an intention to rob a bank if the coast is clear is a conditional intent, but an intent nonetheless. The claimants further argued that the judge had confused intent with desire. The mind, they said, might not have wanted the violence to be used, but intent could still be conditional in those circumstances. For example, it could be used if necessary. The claimant's argument on appeal was roundly and rightly rejected for really three broad reasons. First, the Court of Appeal said that their argument was based squarely on foreseeability. They said that foresight, though, is a very different thing from intent, whether that be conditional or otherwise. The mere fact that a party can foresee that an event might happen in the future does not automatically mean that that party intended that possibility to eventuate. The Court of Appeal said, in respect of the example I gave earlier of robbing the bank if the coast is clear, an example of conditional intent, in those circumstances, you still intend the underlying crime to be committed, and so you would be liable as a joint tortfeasor. But by way of contrast, you may lend a friend a car because he is in such dire financial straits, and you may foresee he might be desperate enough to rob a bank. But just because that is foreseeable does not mean that you intend him to use your car as a getaway vehicle. There is an important and a critical distinction between foresight and intent. Foresight might assist in proving intent, but foresight alone is insufficient. Second, the claimant's argument went well beyond the established boundaries of the law on common design. It was very much closer to claims based on knowing assistance. And that may be sufficient to found liability in other areas of the law, in the criminal law, in equity, but it is not sufficient in the law of tort. In tort, it is not sufficient to found liability in the supply of an item which is put to tortious use, simply because you know that it may be put to tortious use. If otherwise, there could be a whole host of claims against parties pursuing perfectly lawful aims. The classic example given is if you sell someone a gun, knowing that he might kill someone with it, that alone is not sufficient for common design. The vendor must also intend that he should do so. The third reason, to the extent that proper inferences were to be drawn in relation to the provision of money, vehicles, and accommodation, that needed to be viewed taking into account the general characteristics of the police and the particular circumstances that existed in the environs of the mine, as was set out in some detail by Neil in the introduction. As was found at first instance, none of the acts of assistance provided by the mine could be said to amount supporting the police in acting unlawfully. On the contrary, they were said to be entirely understandable given the situation on the ground. In fact, it was much more likely that the resources were intended to assist the police in keeping the peace, rather than assisting in unlawful means to quell protest. Put quite simply, these were not the facts upon which in this instance intent could be inferred. The Court of Appeal also emphasised a particularly important practical point, not just for those advising MNCs operating in the developing world, but a practical point of wider import, and it's this. The mine, in asking for the assistance of the police due to a difficult security situation, and providing assistance where necessary to allow the police to do their job, did not mean that the company had intended or had the common design with the police to commit acts amounting to trespass to the person. If it were otherwise, anyone who called the police in a tense situation where overreaction was foreseeable, such as by way of example and relevant to my beloved Birmingham City Football Club during the West Midlands derby, and provided them with nourishment or other assistance, they would be liable for the actions of the police once they arrived at the scene. All in all, the mine's actions were far removed from the facts of the first instance decision in Shah and Gale, which the claimants sought heavily to rely upon. In that case, the defendant, Mrs. Gale, had pointed out the address of a man she knew would be beaten up by those she was giving directions to. Intent could easily be inferred. The purpose and the sole purpose of pointing out the address was that the occupant would be beaten up. And similarly, far removed from the facts in Fish and Fish, when the promotional documents in relation to the campaign against bluefin tuna fishing made it clear that violent intervention was envisaged. Again, intent could clearly be inferred. In any event, Lord Justice Coulson concluded that the claimants hit a brick wall in respect of this argument, given the trial judge, having heard all of the evidence, and best placed to form a view on whether the mine or its employees had intent, whether conditional or otherwise, he concluded that there simply was no intent. And having concluded that the findings of intent at first instance were insurmountable, and that the necessary intent could not be inferred in the minds of anyone, the Court of Appeal did not consider it necessary to address the question of attribution. It suffices to say at this stage that the trial judge had concluded that for a company to be held liable for the entire sequence of events, it was necessary to establish the company's intention was at the level of senior management, and that's relying upon the well-known Meridian Global case. For present purposes, we think the judge was right. For a company to be held liable for the entire sequence of events, it is clear that what is proposed is a primary rather than vicarious liability on the part of the company. In such circumstances, it seems that the necessary intention must be at the level of senior management. Well, ladies and gents, having raced through common design, I am now going to pass you over to Andrew Bershadski, who's going to look at the Court of Appeal's approach to the question of duty of care.
Good afternoon, ladies and gentlemen. One of the ways in which the claimants framed their case was that AML was negligent in the way that it dealt with the police, and that negligent conduct caused the claimants their injuries. The position taken by the defendants throughout the life of the case was that on fundamental basic tort principles, AML did not owe a duty of care in negligence in relation to the independent criminal acts of a third party. And we said that that was plain from established long-standing authority such as Smith and Littlewood's, the 1980s case about the vagrants who caused a fire in a cinema. So there were really three issues in the case on duty of care. First of all, did that general rule against the liability for the acts of third parties apply at all? And the essence on that issue was whether the defendant's involvement could be said to have been acts or omissions. The second issue was that if the general rule against liability did apply, were any of the exceptions to the lack of a duty of care engaged in this case? And thirdly, if one didn't need to apply those exceptions, then on general principles, did a duty of care arise? So I'm going to quickly take you through how Mr. Justice Turner and the Court of Appeal dealt with those three issues. On the first question of whether the general rule against liability applied, the Court of Appeal, in the judgment of Lord Justice Coulson, found that there were a number of reasons for why the general rule did apply. The first was by looking at the pleadings in the case and the particulars of negligence that were pleaded against the defendants. Looking at those, it was clear that the majority of the particulars of negligence were of alleged omissions on the part of the defendant. For example, you, the defendant, failed to create an adequate risk assessment. You failed to train the police. You failed to get involved in a dispute between the people and the police to try and help resolve it. So the Court of Appeal looked at those and saw that quite clearly the essence of the case was that the defendant had failed to take some additional steps, that it had omitted to take steps to protect the claimants. Secondly, the Court of Appeal looked at the actual breaches of duty that had been found by Mr. Justice Turner. And he had found that if there had been a duty of care, there would have been a number of breaches, in particular, failing to conduct an adequate risk assessment. And the Court of Appeal said this: well, all of the breaches of duty that Mr. Justice Turner found were all omissions. So it can't be right that the claimants can rely on just a number of omissions that were found to have been a breach of duty, and to then use those in order to establish a duty of care in relation to all the allegations that had been pleaded. And thirdly, and most importantly, Lord Justice Coulson said this, that stepping back from all of this, it was clear that the essence of the case against the defendants was that they had failed to take adequate steps to protect the claimants from a third party, and that properly viewed, that was an omissions kind of case where prima facie no duty of care arose. And the key paragraph from his judgment for that point is paragraph 128, where Lord Justice Coulson says that the general prima facie rule against liability applies in all cases where it is said that one party has failed to protect the claimant from another party. So the conclusion on that point is that rather than getting too bogged down in what can sometimes be a somewhat artificial and sterile exercise into dividing particular conduct into acts and omissions, the point is that if the essence of the case is that somebody is said to have failed to have protected the claimants from acts by third parties, then the general rule against duty of care will apply. So the next issue was whether any of the exceptions applied, and there are a number of gateways by which a claimant can establish a duty of care in a situation like this. The three gateways are, firstly, where the defendant creates a state of danger, which is then used by a third party to cause harm. Secondly, where the party that causes harm was under the supervision or control of the defendant. And an example of that is the Borstal Boys Home Office and Dorset Yacht case, where the Borstal Boys were under the supervision and control of the Home Office. And the third way that a duty of care can be established is if the defendant has assumed a responsibility for the conduct of the third party. Mr. Justice Turner found that none of those gateways or exceptions applied in this case. But the only gateway which was appealed and had to be considered by the Court of Appeal was the creation of a state of danger. And it was said by the claimants that the defendants, by their relationship with the police, had created a state of danger for the claimants. The Court of Appeal rejected that argument on two fundamental grounds. Firstly, it was held that the fact that the police had created a danger and their dangerous nature was something that had been a long-established fact of life, long prior to the involvement of the defendant. So it couldn't be said that it was the defendant that had created the state of danger. It was already there. And the second point was that it couldn't possibly be said that by having a relationship with the state police forces, that is the sort of thing that can amount to the creation of a state of danger. The claimants sought to draw an analogy with the case of Hartwell and the Attorney General, and that was a case where a police force had given a gun to a highly unstable and unreliable person. And Mr. Justice Turner and the Court of Appeal in our case said that one can't equate giving a gun to an unstable person with relying on the official state security forces of another country. So the analysis of the Court of Appeal is very important on the creation of a state of danger exception. But it is also important, I think, to turn back to the judgment of Mr. Justice Turner, because he also dealt with the assumption of responsibility gateway at paragraph 363 of the High Court judgment. And that was an issue that wasn't appealed. So it needs to be looked at in the original judgment. The third broad issue that Mr. Justice Turner and the Court of Appeal dealt with was whether, if all of that was wrong and one didn't need to go through one of the gateways, applying basic first principles of a duty of care, did a duty arise? Now, foreseeability wasn't an issue in the case. It was foreseeable that there might be some harm emanating from the Sierra Leone police force. But the Court of Appeal said that it was the other two ingredients of the classic Caparo and Dickman test that weren't met. There was no proximity between the defendants and the claimants. The claimants were all members of the public. They didn't have any particular relationship with the respondent. They didn't form a part of an identifiable group of people who were at any particular risk. And for that reason, the Court of Appeal held that there was insufficient proximity between the claimants and the defendant. But the Court of Appeal held that in any event, it wouldn't be fair, just, and reasonable to impose a duty of care. Ultimately, given that the defendants hadn't intended the police to cause any unlawful harm, it was hard to see how it could be fair, just, and reasonable, nevertheless, to impose a duty of care. And ultimately, what the defendants were doing was relying on the official state security forces, the police of another country. And it wasn't fair, just, and reasonable to impose a duty of care in relation to their acts. And thirdly, and very importantly, Lord Justice Coulson dealt with the argument that the Voluntary Principles on Security and Human Rights was a document that could be used to impose a duty of care. And Lord Justice Coulson analysed that document and said that actually, if one looks at it, the prime responsibility for avoiding human rights abuses in a country is that of the state security forces of that country, and not of a private entity such as African Minerals. So ultimately, the Court of Appeal held that this was a case where prima facie there isn't a duty of care because it was a third party that had caused harm. None of the gateways applied. And even if one stood back from it and looked at first principles of duty of care, no duty of care was owed. Thank you very much for listening to our talk. I think the original slide that we had on is going to be put up again, and that's got our email addresses on it. If you have any questions about the case, then you're welcome to get in touch with us directly. And as Neil has said, the decision of the Supreme Court as to whether permission to appeal has been granted is awaited. So no doubt you'll hear further about any developments in the case. Thank you very much for listening.